Hi everyone, good afternoon. Thank you so much for being here. I am delighted to welcome you all here for the second talk in our inaugural lecture series of the Center for Global Law and Justice, Issues in Human Rights and Humanitarian Law. There are sign-up sheets circulating around. If you'd like to be on the mailing list of the new center, please sign yourselves up. And I just want to draw your attention to two upcoming, we have several, but two upcoming events. One is that next week in this room, same time, same place, we will have a talk by Professor Vasuki Nasaya of NYU, the Gallatin School, speaking from her new book, International Conflict Feminism, on victim, gender as tool and weapon, which I think will be fantastic. And on October 24th, we will be launching the new Center for Global Law and Justice. My co-director Martha Davis is here, Professor Martha Davis is here as well. You can find the information on our website. Please register. People in my class also please register, even though you have to come. There, Justice Natalia Angel Cabo of the Colombian Constitutional Court will be speaking about some upcoming cases on their docket, and it will be really exciting. And there will be food and drinks, so you should all come. And now on to today's event. I am really honored and delighted to welcome Professor Karen Engle today here. Karen is the Minerva House Drysdale Regents Chair in Law and founder and co-director of the Bernard and Audre Rapoport Center for Human Rights and Justice at the University of Texas Austin School of Law, as well as an affiliated faculty member of UT's Latin American Studies and Women's and Gender Studies. She teaches courses and specialized seminars in public international law, international human rights law, and legal theory. She writes extremely broadly on social movements and law, particularly international human rights law, international criminal law, and Latin American law, and I suggest that you look up her entire corpus of reading. I know some of my students already have. She's the author of many articles and several books, including The Grip of Sexual Violence in Conflict, Feminist Interventions in International Law, and The Elusive Promise of Indigenous Development, Rights, Culture, Strategy. Her talk today is entitled An Abolitionist Critique of Human Rights, Rethinking Responses to Gendered and Racialized Violence. So Professor Engle will speak for about 30 to 40 minutes, followed by a response by our very own Professor Daniel Medwed, University Distinguished Professor of Law and Criminal Justice. And I will then open it up to Q&A, and for those who are joining us on Zoom, I'm happy to moderate questions from Zoom as well. And with that, welcome Professor Engle, and thank you all for being here.
Thanks so much, Zena. And gosh, it feels, the last time I was in this room, it didn't look like this. So nice digs you all have. And it's really wonderful to be here in Northeastern and in Boston on this beautiful fall day. I left 90-degree temperature still yesterday afternoon. And to see some old friends and to see new faces. So I'm really grateful to Zena and Martha and the Center for Global Law and Justice, and congrats on that new center, for inviting me to speak. To Daniel Medwed, who I've only met on Zoom and only once, but I've known about forever. And so I'm really excited to hear his insightful comments. And then to the students in the class for your engagement. And I appreciate the papers I got, so would you all raise your hands just so I know who you are? Meredith. Hi. And Anna. Hello. And then the late one. Chloe. I had to write it down off my email.
To be fair, she submitted it before, but it didn't go through.
I'm sure. Anyway, they were really great papers, and I really appreciate your engagement and questions, and maybe we'll respond to some of them along the way, but certainly afterward. And also it was good to kind of get a sense of what maybe some of you all had talked about in the class generally. Just to say, this is a book manuscript, a little book, and it's being sent out to reviewers, external reviewers, in a couple of weeks, and then I'll have some time to make changes. So this is great timing to get everyone's feedback. And though this project is quite recent, I should say I've been in conversation with Professor Miller about some aspects of it for, I was thinking, at least 10 years when we co-edited a book on anti-impunity in the human rights movement. And well, that came longer because that came out after a few years of work. And that was specifically on the carceral turn in human rights and transitional justice. And then we've gone back and forth on ideas for some time and kind of put together, even we're involved in a conference on what would it mean to think abolition and human rights together. And the abolitionists all came and were like, oh, this is great. And no human rights people really wrote papers, or they thought abolition meant death penalty abolition. So we didn't really get to push things that far. So I'm finally doing it, and this is a great place to, I'm very glad to be presenting it here for the first time. So the broad question I'd like to pose for you this afternoon is about the commensurability of movements for prison and police abolition with human rights law movement and discourse. And it starts with a problematique. That's what they call it in the Cambridge University Press element world. So the problematique is that most vocal abolitionists have long considered human rights to be central to their aims, as I just suggested, but most human rights advocates have not prioritized or even supported prison or police abolition. Now, those two groups agree on many matters and often see each other as allies. They all, for instance, oppose police abuse, poor prison conditions, and racist, homophobic, and gender-based violence. Yet they view the causes and responses quite differently. While abolitionists refuse the ideologies and practices of the carceral state, human rights advocates often depend upon them, embedding a carceral response to human rights violations in human rights law and institutions. And that is, human rights law today regularly imposes on states the obligation to investigate, police, prosecute, and punish human rights violations. Now, in part to highlight the differences in approaches that are often missed, including by abolitionists, I use a broad range of prison and police abolitionist thinkers and activists over the past 50 years, from Norwegian sociologist and prisoner rights activist Thomas Mathiesen in the early 1970s to Black feminist and queer abolitionist theory and activism today. And I do so to argue that human rights law and advocacy should stop calling for increased punishment or policing. I contend that even if human rights actors use penal approaches to call attention to significant harms that they believe should be attended to and that should be attended to, thereby deploying, we could say, the expressive function of criminal law, they nevertheless prop up the criminal punishment regime and foreclose alternatives to it. And at the same time, they provide an alibi for adjudicators and advocates alike, facilitating their ability to claim to address and take seriously certain human rights violations without attending to structural harm. Now, I'll make my arguments specific to the European human rights system today, as I have in the draft that I circulated. And I'll argue that the European Court of Human Rights, and I'll sometimes say the ECTHR, or if I just say court, that's what I'm referencing, and the advocates that engage in strategic litigation before it should break away from the dominant carceral trend in human rights law and advocacy by returning to some of their earlier approaches to finality, heeding their own insistence that the European Court is a human rights, not criminal court, and expanding their remedial imagination. And I'll do so in the following way. First, I'll consider some similarities in the origin stories of penal abolition movements and human rights, and then look at some of the resonances and dissonances of abolition with actions of the Council of Europe and the court. Next, I'll home in on two areas where I think that the ECTHR has been the most anti-abolitionist and yet the least critiqued. And those are the cases involving gender, sexual, and racial-based violence, and relatedly, those calling forth active police responses. Along the way, I'll present some abolitionist critiques, and then I'll conclude by sketching what I think could be the contours of an abolitionist court, or at least one committed to penal minimalism that engages in what abolitionists call non-reformist reforms. I don't think it's a very radical call, but some might differ. and have differed. It's one that is aimed at getting the court to take seriously its commitment to racial and gender justice, obligating states to police and punish can no longer be a way out for the court or for states. First, a word about the ECTHR and why I've chosen it for what I hope will be part of a larger comparative study. So the court is sometimes called the Strasbourg Court for where it meets. It was established in the 1950s by the European Convention on Human Rights. And it was established to adjudicate claims brought by individuals against Council of Europe member states. And that was originally 10 states, it's now 47 states. I decided to start with Europe and the European Court for several reasons. First, early abolitionist thought largely emerged from Europe, particularly in the prisoner rights movement. Second, at least certain parts of Europe and the Council of Europe as a whole have in fact pursued a number of important penal reforms, I think especially from sitting here in the United States. Third, the court is the only human rights body I've seen that has acknowledged the ways, or at least judges have acknowledged, some of them have acknowledged the ways that as former Judge Françoise Tolkens, who is a Belgian criminologist and legal scholar who was on the court for many years and president for some time, the way that she put it, human rights had shifted from being a shield to becoming a sword in the practice of the court. Relatedly, she constantly reminded the court that criminal law should be the last resort, which is more of a penal minimalist position. It has been taken up by some other human rights courts occasionally. That falls short of abolition, but I think it can go a long way. And finally, while I think that there's a lot to learn from early abolitionist thought in Europe, it was missing some things, and it didn't continue in the same way that it has in the United States. So I think that Europe has a lot to learn from contemporary Black, feminist, and queer movements for abolition in the United States. So Europe might not have our mass incarceration rates, but the region is far from immune to racialized and gendered violence. So let me start by looking at some of the resonances and dissonances. As I mentioned at the start, abolitionists often stake their claims in, or at least see themselves as aligned with human rights. Ironically, that's true even in the US, where human rights carry a little weight, some might say. Angela Davis, for instance, has long framed abolition as a human rights issue, including by relying in her 2003 book, Are Prisons Obsolete?, on Human Rights Watch report. So at least that could be useful from the 1990s on prison conditions in the US. Now, the reasons that abolitionists might find human rights to be of assistance in their aims. For several decades, human rights law and movements focused largely on due process rights of the accused, prison conditions, and even on getting people out of prison. But at a doctrinal level, the ECTHR enshrines, has through its jurisprudence enshrined convention rights of the accused, particularly those around the prohibition of torture and inhuman and degrading treatment, Article 3, Article 5's right to liberty and security, Article 6's right to a fair trial, and Article 7, which prohibits punishment without law. And these provisions, along with some of the court's jurisprudence interpreting them, are in fact what Judge Tolkens and others have looked at as the shield function. Relatedly, in Europe, penal abolitionists in the 70s were largely connected to prisoner rights movements. And they struggled with many of the issues that abolitionists struggle with today. Unfortunately, human rights advocates don't struggle with them so much, but they were kind of one and the same at the time, so I think that there's some possibility. And that issue is, should those who argue for abolition in the long term support or even promote in the short term the more humane treatment of prisoners? Most notably, Norwegian sociologist Mathiesen, Norwegian sociologist of law, who I mentioned, who was really arguably the leading thinker on abolition internationally from the 70s into the 21st century, coined the language that is key to abolitionists throughout the world, distinguishing reformist reforms from reformist reforms. So reformist reforms, which are what he opposed, are changes which quote, improve or build up the system so that it functions more effectively. Abolition is made more difficult by these reforms, partly due to what he termed the renewed legitimacy which an improvement bestows on the system. So he supported instead non-reformist reforms, which are, quote, changes which abolish or remove greater or smaller parts on which the system in general is more dependent. Or as leading abolitionist Ruth Wilson Gilmore puts it, non-reformist reforms are those reforms that rather than supporting the carceral state, aim to, at the end of the day, unravel rather than widen the net of social control through criminalization. So let's turn to some of the reforms over the years by the Council of Europe and consider their resonances and dissonances. And I'm just going to kind of go resonance, dissonance. So, resonance. In addition to the shield provisions, the European Court has also led the way on some decriminalization, particularly regarding sexuality. So, 1981, the Dudgeon versus UK case, the court became the first human rights body to find that the criminalization of sodomy violated human rights law. Just a year earlier, the Council had published a report on decriminalization, which was drafted by a committee chaired by prominent Dutch penal abolitionist Luc Holzman, and it had broad ambitions. Dissonance. Unfortunately, the court hasn't pursued many of these decriminalization efforts, and sometimes this is going to sound like it's a periodization, but it's not totally, you'll see. But here it was, the old. What's happened, even as recently as this summer, is that the European Court ruled against a case that was brought a complaint by sex workers in France who challenged the criminalization of the purchase of sex work. And the court took a very long time to decide that, but ultimately ruled against them. Okay, another resonance. The Council of Europe and the court also correctly see themselves as pioneers for the abolition of capital punishment. And the court limited its use in the 1980s, and the council made abolition of the death penalty a condition of accession in 1989. Now, while in the US, we've also seen a decrease in capital punishment, but not because of that kind of legal decision. It's led to, that decrease has led to a significant rise in life without parole sentences. But Europe has gone a different direction, with the court prohibiting life without parole and insisting that all prisoners are entitled to the right to hope or the possibility of rehabilitation. Dissonance. At the same time, the court does permit long sentences and even life sentences, or sentences that might happen to last a long lifetime. And rehabilitation, of course, assumes that people had actually committed crimes that they were convicted of and had a reason to be rehabilitated. Another resonance, as advocated by many prisoners' rights groups, the court has protected a broad range of civil, political, and even economic and social rights of prisoners during confinement, some of which are arguably non-reformist reforms. So indeed, in one of the only pieces I found to address head on the question whether abolition and human rights are compatible, Isabel Renzulli finds some glimpse of abolition in court rulings about overcrowding that require that states decrease their reliance on prison sentences and look for alternative measures. But now I'll just go to dissonance. The concern is, by some, that the focus is on pretrial detention. So I think Professor Medvin might have something to say about that, because it's very much a focus on right before people have been convicted and they're still presumed innocent. In terms of police abolition, the courts attempted to curtail police brutality through cases that proliferate the case law. It's found many states responsible for excessive use of force by police in violation of some of those same articles that I just mentioned. And it's found some of these actions also to violate the prohibition on discrimination, given the enormous amount of policing that affects the rights of racial, ethnic, religious, and sexual minorities. Through these cases, the court implicitly, at least, suggests a variety of forms that need to be taken by police, which the Council of Europe has actually detailed in a handbook that is drafted up, and I'm sure in other places as well. Dissonance at the same time, the court's response has primarily been, so it's calling attention to this violence, but it's primarily been to obligate states, again, to prosecute and punish. And the handbook actually sets the stage for, I think, increased funding for policing by calling for training and development of professionalism. And that's something that abolitionists nearly always oppose, which I'll say something more about in a bit. So now I'll turn more directly to the case law that arguably undermines even the best non-reformist reforms here, or at least 10%. And in what Lawrence Laverson and Natasha Mavroniccola referred to as coercive human rights in the court's jurisprudence, the courts used, again, some of the same provisions of the convention that support the rights of the suspected, accused, and convicted to hold states accountable, often criminally, for various human rights violations. So that is, it's required states to enact or interpret criminal legislation to cover certain conduct. It's held them accountable, states accountable for not investigating, prosecuting, or punishing again, including by limiting prosecutorial discretion. And it's found sentences to be too lenient to actually be manifestly disproportionate to the harm. And it's interesting because usually that manifest proportionality works to the, everywhere, but in this line of cases that I know of, it works to the benefit of defendants. So I want to look at that case law, but with an eye toward two aspects of the jurisprudence that have not been attended to or of which even the critics have been less critical. And that is the way that groups seen as vulnerable or historically subordinated are often used to justify criminal sanctions. And relatedly, the court's calls for increased policing, especially, but not only for some of those same crimes and groups. So, first, increased punishment. And increased punishment often is justified. States are obligated to engage in it, but even to increase it, often because certain groups are considered to be especially deserving of criminal law. So part of the court's jurisprudence, in fact, the part that's often seen as the most progressive, suggests that those who are vulnerable or are part of historically subordinated groups are particularly deserving of or in need of criminal law. Indeed, the court has made over 500 references to vulnerability in the merits of Article 3 cases alone to describe children, victims of sexual and domestic violence, and members of the LGBT community. While acknowledging that being deemed vulnerable does not always prove to be empowering, one critic, even of the course of human rights in general, ultimately supports the vulnerability designation because it, quote, acts as a magnifying glass, making ill treatment look bigger. And I think that's clearly the expressive function that's happening with criminal law here. Now, one area in which the court has used vulnerability to increase the positive obligations of states is in the area of domestic violence. So in Opaz versus Turkey in 2009, the court handed down this landmark case that found domestic violence resulting in death in that case constituted not only violations of the right to life and inhumane and degrading treatment, but also discrimination. And the court considered that the victims were particularly vulnerable in that case and used the discourse in part to find the state accountable, and I think in part to give little credence to the fact that the victims had actually dropped their complaints against the perpetrator. Later cases consider victims of domestic violence to be per se vulnerable and requiring state protection. And the court has also found states liable for failing to include domestic violence as either a separate offense, which would increase punishment, or as an aggravating element of other offenses. The court has also required increased criminalization of punishment for racially motivated violence. These cases largely concern police violence, often against the Roma, with multiple claims having been brought against Italy and a number of Eastern European countries. The landmark case here is Minerva versus Bulgaria in 2005, which required that Bulgarian law distinguish, with regard to police violence, cases of excessive use of force, so ordinary police violence, from those cases of racist killing. In subsequent cases, the court applied the same logic to non-state violence and also to non-lethal violence, requiring states to make racially motivated violence a separate legal offense. And I want to say here, the court was not necessarily on the cutting edge of this. It's actually following what's required by the Committee on the Elimination of Race Discrimination and even the convention. So there are a lot, and it relies on CEDAW and some of the domestic violence. So in general, this is part of the move within human rights. The court has also followed a similar approach toward crimes with possible homophobic or transphobic intent, often citing the race cases and holding that violence and brutality with discriminatory intent must be treated differently from, quote, cases that have no such overtones. Most of the cases find the state failed in its positive obligations to use its police powers to protect individuals from hate crimes or to investigate adequately the crimes once they were reported. And some of those states also find the state responsible for discriminatory ill treatment by police. So you can see, I mean, this is how police abolition came about in the United States, right? It was largely in response to police violence, and then what's the next step? In nearly all of these decisions, they actually say that the motive should be treated as an aggravating factor, again, increasing the punishment. So many human rights NGOs, particularly feminist, anti-racist, and LGBT, have been behind, and I don't know whether to say Q for reasons that will maybe become clear, have been behind the strategy that led to these decisions, lauding them for the ways that they've increased obligations on states. So these are human rights NGOs. They've assumed that obliging states to apply harsher punishment not only would deter the harms, but would, and I think again, what they're most concerned about, would give greater attention to them. And that lauding, though, neglects the thoughts and activism of abolition movements around the world, many rooted in feminist, anti-racist, decolonial, and anti-gender binary struggles. And some of this thought is not new. So noting that amnesia about anti-carceral feminism is too present in France. French feminist François Verger has recently gone back and looked at debates back to the 70s involving feminists. I can talk more about it, but this has been the main target of a lot of the critique of abolitionists in the United States as well, and again, very much centered in the feminist, anti-racist, and queer struggles. Queer abolitionists have maybe been particularly vocal, most explicit opposition to the hate crimes legislation. And they've done so by arguing that hate crimes laws, and so that, I want to say this is the queer abolitionist theory as opposed to the LGBT human rights groups. They argue that hate crimes laws not only, quote, place our safety in the hands of the very criminal legal system that is a major perpetrator of anti-LGBTQ violence, so you can imagine how that reverberates in other areas, but that those same laws are retrospective, they're aimed at a few bad apples, and that they're ineffective. And as Dean Spade has argued, they also fail to, quote, address the violent imposition of racialized gender norms that structure all the forms of the confinement where people and people of color are concentrated under various administrative regimes. So it's sending people to be punished in places that themselves are part of the problem. If many anti-discrimination advocates have fought hard to make the state accountable for so-called private acts of violence, which is what makes actually a lot of the court's jurisprudence seem path-breaking. So I told you about some of the state violence, but a lot was non-state violence. Those who fight anti-Black racism, homophobia, and transphobia often remind us that state's criminalization is part of the problem. So the second idea is, that's sort of more about the criminal punishment, prison, carceral aspects. But there's also, the court has been calling for increased policing. And that is what I think no one has really paid that much attention to. And I found it in a couple of cases and have been seeing it in more. So many of the court's decisions, including some that I've already discussed, as I said, fault the police for inaction or passivity. So it's the lack of police action, and it sits in tension with the many cases the court hears in which the police have overacted. So it's sitting with these two ideas, including many of the same groups. And for me, that means that we should be thinking about whether to call for more policing and to bring forth a police abolitionist perspective that would aim its sights instead on defunding the police with the goal of redistributing resources and abolishing policing as we know it. So at a general level, I think human rights necessarily, this trend calls for more policing, and I can say more about that. So it was sort of already there. There's an incentive for police to act before their state is found liable. But other cases more specifically call for increased or more active police presence, faulting police for inaction again. And the cases where we see that the most is in domestic violence cases, not surprisingly. I mean, I think that's pretty common in general. I lost a page. No, I didn't. I just lost it. And so domestic violence is a big chunk of cases that does that. Another is one that calls for increased policing around protests, which I think are particularly interesting and in the context of LGBTQ protests. So a recent case against Georgia provides a vivid example. The state had deployed 2,000 police officers. So after it had been told it wasn't doing enough to protect them, one year, the next year deployed 2,000 police officers to protect participants at an LGBT public rally. And this is Georgia in Europe state. When counter-protesters committed acts of violence against those in the rally, the court faulted the government for actually not equipping law enforcement officers deployed to the scene with appropriate riot gear. So it said you sent 2,000 police officers, but you didn't give them the tools they needed. But at the same time, the court actually found that some of the police had aided the counter-protesters by opening up a cordon that the police had erected. So in those circumstances, it seems hard to imagine how arms and riot gear would make the situation better, might make them worse. And it doesn't take much to imagine the police then using a case like that, or the state to call for greater funding allocated to the police, which would be a definite reformist reform according to abolitionists. So again, these cases have been lauded by human rights advocates, and yet they engage in a variety of moves that abolitionists oppose, or would oppose if they knew. So many feminists who oppose increased engagement with the police, for instance, point to the extent to which the very communities that experience over-incarceration are most likely to be subjected to the criminalization of domestic violence. And they commonly note that increased police response leads to incarceration of victims and survivors of domestic violence, particularly when, and in the United States, especially when we have mandatory arrest laws. Feminist abolitionists also emphasize that police officers are also perpetrators of domestic violence, sometimes to an alarming extent, and that was actually the case in one of the European court rulings. Abolitionists also identify increased police training, as I just suggested, as a reformist reform for a number of reasons. US-based critical resistance explains not only will more training require more funding and resources going to police to develop and run trainings, but even promoting training furthers the belief, which of course they think is false, that better training would ensure that we can rely on police for safety and that instances of police harm and violence occur because of lack of training and not something else. Some of these tensions have emerged around pride marches around the world, to go back to not necessarily protests, but demonstrations, with queer abolitionists arguing against allowing uniformed police to march in pride, and sometimes even arguing against police so-called protection. Okay, so what do we do with this? And, you know, we could say, we need to make the world, I need to come up with solutions for all of these 47 countries. And, you know, the US while I'm at it. for how to move forward to abolition. But in many ways, I actually, because I'm looking at the European Court of Human Rights, I have kind of a modest claim that I think I end up making. So you have a sense of where I'd like things to go, but I don't think the court can do it, but I do think that it might be able to do some things. So there are lots of people who are proposing reforms and alternatives out there, and who are much better equipped to do that than I am. I mean, I'm quite sympathetic to a number of them, but I also think abolitionists make pretty clear that we need to be that solutions have to be locally based. So I recognize, along with Dorothy Roberts talking about the US Supreme Court, that, quote, court decisions alone will not abolish prisons, but they can, quote, weaken many of the practices that help to reinforce and explain them. So I thus sketch how the court might participate in such weakening while also better addressing the needs of victims and effectuating structural change. So I kind of want to harness that, what's coming out in increased punishment. So that expression, and I want to apply it to better obligations on states. So I think importantly here, the court would not need to expand its competencies for many of the suggestions I articulate. If anything, I'm asking it to shrink its capacities. By taking seriously its oft-repeated claim that it's not a criminal court. It says that over and over, it's not a criminal court, it's not a human rights court. Okay, you're a human rights court. Why don't you think differently? But we have to get human rights to be thought differently. But it would heed the warnings against the court's deployment of criminal law as a sword. So again, one of the reasons I like some of the discourse in Europe, and its history of encouraging non-reformist penal reforms. And at the same time, again, it should channel that condemnation of gendered, sexual, and racialized violence and its commitment to holding states accountable to it. So much of what I propose should be persuasive and is even derived actually from some who don't necessarily identify as abolitionists. And that I kind of suggested early on that there's a fair amount of penal minimalism in Europe. But I want to end here, well, and maybe to say in that vein, I encourage the court to continue to pursue some of those resonances I laid out at the beginning. So we could go resonance, dissonance, resonance. And there's some good proposals about that. But I want to end here by thinking about how the court might promote broader responses to the harms themselves in the ways that it holds states accountable for gendered and racialized violence. And in that regard, perhaps the most straightforward abolitionist change that the court could make is to stop imposing positive obligations on states to use or ramp up their penal apparatus to respond to serious human rights violations. While not requiring penalty is a necessary first step, it is of course not sufficient. So for a while, the project kind of ended there. Got some new energy. It would fall short of the court's commitment to preventing and holding states accountable for serious human rights violations. So the court should maintain and even reinforce that commitment, but rather than imposing positive obligations to increase penalty, it should get states to use other tools, existing and new, aimed at both repairing individual harm and remedying the structural conditions under which violence occurs. So as one advocate, not quite of this, but of maybe penal minimalism has said, right, maybe it shouldn't be policing, well, we should have policing, prosecution, and punishment, she says, but we should pay more attention to preventing, protecting, and providing redress. So there's a lot of keys, and I'm just gonna go with the last three. Prevent, protect, and provide redress. So the court could give states a fair amount of latitude in their choice of, though not their commitment to non-penal responses. Although no, states, this isn't saying states, it's not saying states are gonna be held accountable for using criminal law, unless they're violating the rights that we're already looking at. But if they aren't getting results, they're gonna be held accountable, and they're not getting results. So they have the benefit of the experimentation that abolitionists call for, while also ensuring that states pay significant damages when it's determined they've not put in place sufficient policies to prevent harm at both a structural and individual level. The court could even impose strict liability on states for any case in which there's requisite proof of police violence, which would encourage states to take up at least some of the non-reformist reforms that police abolitionists have proposed. And after hearing from a range of actors in particular cases, and I think the range is really important, the court could tailor state obligations and remedies with both deterrence and support for victims clearly in mind, providing significant guidance as to actions that would be taken and how resources should be allocated to avoid future liability. It might even find that states have an obligation to change other, often backgrounded laws that limit opportunities for subordinated groups. So that would get away from criminal law a little bit, such as family and property law. So the idea shouldn't be just change your criminal laws, it's actually make the conditions better. And in addition to promoting structural change, the court should also pay more immediate attention to the victims that come before it without assuming that criminalization is in fact what they want or need. And we can talk about this later, but Thiessen, who kept writing, wrote in 2015, rather than increasing punishment of the offender with the gravity of the offense, I would propose increased support to the victim with the gravity of the offense. In other words, not a punishment scale for offenders, but a support scale for victims. I mean, of course, the abolitionist aim is to get beyond that altogether, but again, these are reforms along the way. So I looked at, it's really hard to find much on the European Convention about how it determines damages. But I can tell you, just looking at the the police violence cases, racist police violence cases, that, well, first of all, what is being awarded and even asked for is just like significantly less than anything that you would see in the United States in a civil case. But also, interestingly, so only one case did, especially with regard to non-pecuniary damages, so in only one case did the complainants get what they sought. But it turns out that it actually isn't really determined by what the complainants ask for, that there's some schedule that tells judges basically what they should be awarding. So I argue that that schedule should be looked at and adjusted and have them put their money where their mouth is in terms of taking seriously gendered and racialized violence. If anybody knows more about that, I would love to hear about it. And then finally, given that so many alternatives proposed to criminalization are community-based, the court would want to be clear about the limits of what states alone are able to do. And perhaps states could be allowed to meet some of their obligations by delegating responses to community-based NGOs. But I want to be clear here, and this is in response actually to a question that I'm not clear in the paper, so I will be, thank you, that it's not that they should be necessarily delegating to the NGOs that they normally are delegating to, but they would need to be, they would have a range of decisions about what NGOs, and they would need to be committed to addressing the structural harm through non-carceral means. So, in conclusion, abolition is a long-haul project, and US-based abolitionist Miriam Kaba emphasizes that abolitionist practice is not a blueprint, but it's a process of experimentation. And so what I aim to do here is not only to engage in that process, but to find a way for state and non-state actors to do so as well. And I look forward to your additional comments. Thank you.
I have to go after that. That was incredible. Thank you, Karen. This is a special treat for me. For years, I won't divulge how many years, I've been hearing about how brilliant Karen Engle is. Just like 3 or 4, right? How brilliant Karen Engle is and how I have to read her work. So it really is a wonderful opportunity to engage with her in person. And now you're a criminal law person. So we can claim you to our community.
Because I'm a human rights person.
Well, I mean, my expertise in international human rights, is Rhode Island a different country? It's an island, right? In any event, I love this paper. I thought it was great. I mean, for those of us in the room who've struggled with some of these issues, and I know I've engaged with my students on these issues, there's often a tension within progressive circles between the desire to move toward abolition, that humans shouldn't be in cages, but also the desire to protect marginalized and vulnerable populations. And I think that tension, the idea, of course, is you want to defend anyone, but maybe not Harvey Weinstein, right? And I think a lot of people on the left have had that struggle. Or maybe with the former president, some of us aren't necessarily opposed to the imposition of criminal law punishment. And there's that disconnect, right? There's that disconnect between the desire for abolition, the desire to treat people humanely, and also the desire, or the recognition at least, that there are some bad actors that maybe need to be not necessarily incapacitated, but dissuaded from reoffending. And what I love about this paper, Karen, is that you managed to explore that tension, I think, in the place where it is most resonant, human rights, right? The area of human rights where the whole goal of human rights law, at least what Zena and Martha have taught me, because that's all I know, is to protect vulnerable and marginalized people, to make sure that vulnerable and marginalized people are protected from the potentially awesome and draconian power of the state. And how do you do that in a way that is empowering but not infantilizing? And I think you managed to thread that needle and put forth some proposals that suggest there is a way to empower victims, a way to power marginalized people without expanding or augmenting the carceral state. So I really applaud you for this. I thought it was terrific. I also learned a lot, which is fabulous. So I had 3 comments, just food for thought, to kick things off. 2 are sort of little picture, and 1 is maybe the bigger picture. So the first little picture comment, and this may betray my ignorance about international law norms, is I was really curious, and maybe some students are curious about this too, about the extent to which the court does tend to delegate or defer to national authorities. And you forecast this in your comments, that I would maybe pick up on this, that the court is somewhat vigilant about intervening in areas of pretrial detention or prison overcrowding. It sounds like it hasn't been hesitant to impose positive obligations in that sphere, but it's been sort of hands-off in the sphere of post-conviction sentencing, which is one of my interests. And because post-conviction sentencing, I think, is the sphere of criminal law that is most closely tethered to at least prison abolition. Because when you really think about prison abolition, it's just about the nature of punishment, right? It's really about sentencing. Abolition of the police is something else, and that's about criminal law. But if prison abolition is about sentencing, then I found it curious that maybe the court has deferred to national authorities in the area of post-conviction sentencing, and to what extent would that be a problematic move for them to make if they were to pursue your argument, right? Or is that something that supports your theory? Because in a sense, by the court deferring to national authorities and I think I'm referring to the Snacken research that you referenced, which I haven't read, but I know you have. If they're deferring to national authorities in that space, does that help or hurt the argument that there should be a negative obligation, that there should be a shared movement toward abolition? Or is it just going to create that sort of piecemeal approach to abolition that you would maybe be opposed to? That's my first comment. The second one is about the reparations model, which I love, and you mentioned that toward the end, this idea of support, the scale of support as being a sliding scale based on the harm to the victim, or the not vulnerability, because I know how you might feel about that term, but what about reparations? You mentioned the Chicago settlement, which I'm sort of familiar with. There was an area in Chicago where there was a rogue detective named John Burge, tortured many suspects. And the result of this was not necessarily the criminalization of a lot of miscreant law enforcement authorities, but really a large-scale reparative restorative justice model, which I think is great. So the second question is about, to what extent do you think that reparative model is transferable to the European context? And to what extent, and this again may just reveal my ignorance, to what extent does the court grapple with private violence? Or private violence that is being animated by the state in some way? Because I think the Chicago model works well when the city of Chicago is paying for the reparations. But if private actors are involved, Is that ever something that comes before the court? I just don't know, the European court. And the third comment is, I love, as I said, I think you approach the whole notion of vulnerability and a lot of the literature on vulnerability with such nuance and care, while also basically destroying it. Which I thought it was fabulous. I wish I could do that. And I was curious about sort of an alternative branch of the anti-abolition stream, which is essentially this, right? I think some people who are opposed to abolition view it as a top-down measure that people in the ivory tower or in wealthy enclaves are often espousing, but that many people in vulnerable communities, I shouldn't use the term vulnerable, but communities that are with people on the margins, often will say it is a problem of underpolicing or a misallocation of police resources. That policing in a lot of communities is both over-inclusive and under-inclusive. Over-inclusive in terms of too many drug busts, under-inclusive in the sense that you can't get the police to respond to a 911 call in Roxbury, but in Back Bay they're there in a second, right? So if you go into a lot of communities that do have a larger percentage of criminal activity, reports of criminal activity, the message I've always gotten, and especially from my clients as a public defender, is we need more protection or different forms of protection. So to what extent is abolition disempowering certain community voices? Because the response I've often heard is sort of inadequate to me, which is that it's a failure of imagination for communities to envision a world without prisons. That seems to be coming from a place of privilege, right? Sometimes, when it comes from certain quarters. So I'm just curious about sort of how that argument fits in. Like if there's a community in Europe, a Turkish neighborhood in Germany, a Roma neighborhood in Bulgaria, that is saying we need more protection for our community. We do believe in punishment, even if there's the argument that it is against their long-term interests. How do we articulate, because I see the power of this argument, how does one articulate that argument in a way that doesn't feel top-down, that doesn't feel paternalistic? It's just, I mean, that's a bigger question that I've just always struggled with in the abolition literature. As I said, I just love this piece. I think it's such a major contribution, and I applaud you for it. And I get to see you again, I hope. All the best. Thank you.
Oh.
Yeah. Karen, do you want to respond first and then we'll do Q&A?
Does that make sense?
Yeah.
Okay.
Totally makes sense. Respond to the
Those were easy questions.
He's known for that.
I'm known for that.
He asks easy questions.
Exactly.
That's why we keep him.
Thanks so much. Yeah, so there actually are more than 3 questions. But I'm going to try to get to them. 3 categories of questions.
Exactly.
And I actually think the third one is the easiest. So
Good.
how about that? In some ways.
Yeah.
Just because I think so, maybe to make sure that I have them right. So the first one is about the problem of the deference to national authorities. The second is about, I actually was hearing the second one sort of about large, I thought you were going to go slightly, so I have a more challenging question for myself.
That's what I was asking.
Which is about sort of large-scale reparations versus individual reparations.
That sounds great.
At some level, right? But, and the private violence is easy. And then the third one is basically, so I'll start with that one. That I take that you're saying you understand why it is that it's in the cases of subordinated groups, marginalized groups, that there's often, but then there's sort of a double thing, that there's often support for criminal responses, but I would say that's from the academics as well as from the people affected. So I'm not sure, I guess, so I mean, part of it is I've worked hard in this piece. I mean, obviously when you're looking at work that's published, you're more likely to find scholars, but I really tried to get into some of the movement language as well. And so there's a large part of the piece about, as you know, about the Pride marches, just because I thought that was sort of where we could see some of the arguments play out more explicitly. But also, you know, there are a lot of formerly incarcerated people. Well, there are a lot of formerly incarcerated people who are in favor of punishment and prisons and even increasing, you know, making them better. But there are also a lot of formerly incarcerated people who are abolitionists. So, which isn't to say they can't also be theorists, and there are many of them are theorists. But so I don't know. I guess I want to resist that distinction. I mean, I would take it if I thought that was what was happening, but I don't think that's totally what's happening, because I think I think the people who are pushing for abolition are a minority wherever they are. But I think the under-policing issue, you know, is one that you've dealt with for a long time, and that being relatively new to criminal law, I mean, I've been aware of those debates, and, you know, there were very different responses to them, I think, that a lot of people had 20 years ago than they have now. Because I think, and let's just say, the movement for Black Lives, I think, is very much, you know, it's a grassroots movement in many, many ways, and they're basically saying we want police abolition rather than more policing, because we've seen over time that responding to under-policing by policing was never going to be very effective. In the European context, it's interesting because it's really hard to find a lot of contemporary abolitionist work in Europe that's not just, and then this is where it is more from the theoretical side, borrowing from what they're reading in the United States, and some of the people happen to be living in Europe, but are maybe even American or Canadian or have been, spent a lot of time here. But I found a report that I write about in a piece from a Roma human rights group, which has, you know, primarily been focused on getting these rulings, getting the cases brought against states for police violence. And, you know, they're starting to say, like, actually reforming the police isn't really working. So, you know, part of what I'm trying to do is open some space then for saying, well, actually a lot of people have been thinking about where to take that, and maybe as a movement, folks can do that too. But that doesn't mean that there aren't some people who think that they want punishment. Many, many victims, that's what they want. I also think, you know, that's in a world in which we've been taught to think that that's how you show that something really bad happened. And so part of the idea here is to say, yeah, horrible things really, really did happen, and actually we're going to take seriously attempts to respond to it differently. So on the, maybe I'll go back to the reparations one. First of all, in terms of private violence, every one of those examples I gave that has been extended to private actors. So that's a lot of what, and in fact, really that whole idea of requiring investigation, prosecution, and punishment, interestingly, started in, I think, the first instance that well, it depends on where but let's just say in the Inter-American Court, the very first case that was decided, contentious case in the Inter-American Court, Velasquez-Rodriguez, was an enforced disappearances case. And the court wanted to say, you know, they actually said we're not a criminal court, so we don't need a lot of proof to show this. So the state said, you know, we don't know anything about it. Well, that's what the state does in enforced disappearances. So, like, that's even a part of one of the elements. So it's really difficult to deal with. And so the court said, you know, we don't really care if it was a state actor or a non-state actor. I mean, not that we don't care, but in terms for what we're doing here, we just have to show that the state didn't do what it needed to do to protect the disappeared person. And so then they said, you didn't investigate, you didn't prosecute, you didn't punish. They didn't require that as a remedy, but that was how they found the state obligation. So non-state actors are actually a pretty important part of this, and then that expands the reach so significantly. On the reparations, you know, I gave the example of the damages because the court would be requiring the state to do it. So there's nothing, and I know one of the papers was asking a question about that as well. There's nothing that would say that the states, I mean, maybe that's what the states would end up finding works, but there's nothing that says that they are obligated to fine non-state actors if we're talking about non-state actors. And there's, there would be nothing so far that we can think about it, about saying that they have to, like, actually work toward, where I saw the tension is that I think that by definition, these are cases brought by individuals. That's the only way the cases can get to the court. So I'm trying to get at that by saying, okay, these people came to the court, let's show that we seriously are concerned about their individual cases and make the state pay for it so that they'll have an incentive not to get there again. But also that that's not enough for the state. So the state has all of these obligations to respond, and some of that could be very narrowly tailored, and some of that could in fact require like a larger reparation scheme. And interestingly, so there's, for the larger comparative project, and I've done a little bit of it on the LGBTQ cases, the Inter-American Court has a much broader remedial scheme and possibilities open to it, which it uses. And so that might be something to consider and bring in. And then, but really good question, and I want to think through, and I think it could really strengthen that last section. And then on the deference to national authorities, yeah. I mean, look, this is, so the European Court of Human Rights has explicitly a doctrine called the margin of appreciation, which says that there's certain areas where we defer to states. I just taught some of that last week. And I put up here all the way, this is what goes for narrow, what is said. This is a narrow margin of appreciation. No. Here's a wide margin of appreciation. What does X fall under? And it's impossible. So, I mean, it's really, it is kind of indeterminacy gone amok. So I think that, gone amok, no, it's just indeterminate, but you can see it, it's explicit. They don't even try really to reconcile it. So I think Snacken's saying, look, you did it in pre-conviction, so why not do it in post-conviction? And the Mattia Pinto piece that I mentioned in the article, who's written about that 80s decriminalization approach, actually there, the court, that report, but it was a report written by an abolitionist, was like saying there should not be a broad margin of appreciation here, right? You've got to decriminalize, you should require it. And obviously that didn't work. So I think that that's just sort of an ongoing battle, but I do think, as you pointed out, and maybe I can make more of it, that the fact that the court is requiring so much in terms of obligating states to investigate, prosecute, and punish is actually doesn't sound like a lot of deference. Right. And in fact, right, would mean that a lot of what I'm proposing that it see states do would basically be meaningless under the current, right, as long as they stick only with that obligation. So, thank you. Very thought-provoking.
Great, thank you both. So let us open up. I'm down here so I can see the crowd. And if you are on Zoom and have a question you'd like to ask, you should feel free. I can see you. So,
Thank you for your talk and for sharing your work with us. I really enjoyed your paper. I'm particularly interested in what it might look like for abolitionists to broaden their human rights lens and thinking specifically of human rights commitment to economic and social rights.
That's the kind of question one loves. Because, in writing the talk, I can't possibly get that in there. Yeah, so I say in the paper that there's another, thank you again, Professor.
Child care, sorry.
Yeah, so part of what my original aim with this project was, and it's kind of changed a bit, but was to get abolitionists to say, oh my, maybe these are not the people we thought they were. Their aims are not what we thought. And then what would we do with that? Well, are they really that dependent on human rights? I mean, I think not so much. I think a lot of it is the attention to the discourse. But also taking advantage of those resonances could they push things a little bit? But one of the interesting aspects of it is we think about, well, what do they think human rights is? And for the most part, I think if you look at like the Angela Davis example I gave, or you look at the prisoner rights folks, they're thinking of pretty traditional civil and political rights. And abolitionists, like they're also thinking a lot about a much broader distributive justice, and they don't see that as a part of human rights. So I was just thinking that this might be, and I'd love to think about a way to build that in. I mean, it might be a way to kind of push some resonances a little bit more, but because, and maybe open up a variety of arguments. Well, I don't know. I was going to say some points of agreement between some human rights folks who are a little bit worried maybe about the criminal turn and yet don't want to give up on human rights. So it's like, well, let's take this other really important aspect of your thinking about human rights and see where it would lead. And maybe it would lead to where the abolitionists are, even though they don't know that that's a part of human rights. But it also means that abolitionists, if they're talking about human rights, could perhaps be, that's calling on those larger distributive justice aspects as a part of human rights. So, you know, do I want the abolitionists to spend all their time now thinking about human rights? I'm not sure. But if there's something else that motivated that question, feel free to share it now. Okay.
Professor Clay.
If I could just pick up on that, I think that you actually, in your presentation, said how the response to the question could be built into the paper. So at the end, one of your concluding points was the idea that the human rights space should not just be concerned with the criminal side and the, you know, which leads to this perverse connection between a part of human rights discourse and the carceral system. But you said we ought to be thinking about changing family law and property law.
Yeah.
There was some sentence like that that I thought, well, if we look at the human rights practice as including the economic, social, and cultural rights dimension of it, that's what they do. We're not going to be able to transform property law, family law. We're not going to be able to approach economic and social justice without the strong push that we need from the economic and social rights part of it. So if I could just make a friendly but probably partisan comment, your paper is about a portion of human rights practice. It's not about human rights. There's much more to the world of human rights than the portion that you were so illuminating in discussing. And I think one thing that we ought to be able to do is explain to the public the broad spectrum of what's included in human rights work.
Yeah, no, so I thank you for that. And here's the problem. And I realize, and I really appreciate it because I'm going to have to be explicit about this in the paper. And then it'll open me up to more critiques. But, so the European Court of Human Rights is bound by the European Convention on Human Rights. And the kinds of stuff about family and property law that I'm talking about are not like clearly included. So, and I can't believe, because I totally had this thought at some point and then I realized I never put it into that draft. Unless it's there and I've forgotten it. But, because I think a critique could be that, in fact, what I'm trying to do is sneak in economic and social rights or broader distributive justice aims where they're not supposed to be. So that's for the European Social Charter, and go talk to those folks about it. But I'm totally trying to do it, right? So it's a matter of, do I want to say, oh, in this, right, so who am I writing for? That's a question. Do I want to say, and along the way, we're going to sneak in a lot of, I mean, I've already got structural change, which the court doesn't see itself as doing either. But
you're not sneaking anything in. It jumped out of the text of what you wrote. I think many people understand human rights law as the interpretation and enforcement of human rights treaties, or mostly focused on civil and political rights. If we expand the lens of human rights to include issues that come before national courts on property and family and education and housing and all of those, if we say that's part of human rights as well, then you're not, then the door is open for exactly what you.
yeah, just maybe not in a little book on the European Court of Human Rights. But I'm gonna get it more explicitly in there, because I do have that point too about, right, like it'd be great if abolitionists also had a broader sense of human rights, and that's where I think some of that could be pulled out. Yes.
Well, thank you for your talk. I guess, from what I get from your talk, the U.S. is fairly behind when it comes to prison abolition. And my question is, can you please explain the societal forces throughout history that led to that phenomenon?
Sorry, can you just say that last,
Yeah, I was just asking, why is the U.S. behind when it comes to prison abolition? What are the historical and societal forces that led to that?
That's a big question. But also, so why is the U.S. behind? I mean, it's interesting, right? Because actually, in terms of abolitionist thought and activism, maybe this is the problem of, living in a too small world of people who tend to agree. But the U.S. is actually, I mean, as I said before, like the U.S. has kind of been at the head of that abolitionist thought since, at least in contemporary abolitionist thought, although Mathiasson and others were mostly Scandinavian countries, were sort of people from there were behind it in the 70s. But I mean, I don't know if this is what you're asking, because that's a huge, I mean, I could ask you back, right? I don't, but some people have said that mass incarceration, that the sheer size of mass incarceration in the United States explains, and then maybe they'll say also, and the extreme police violence, that we can't say is unique, right? But mass incarceration is unique, explains the push, the abolitionist push. Is that partly what you're getting at, or no?
So I guess what you're saying is that I was wrong to say that, well, because I misunderstood. I think what you were saying is maybe the U.S. is behind the other countries when it comes to human rights and the law enforcement around that, but I misunderstood.
No, I mean, I'm definitely saying that the reforms, reformist or non-reformist reforms in Europe, many of them we do not have. I mean, we have a lot of litigation about police conditions, and that's always actually kind of been a part of, like, those folks consider themselves to be a part of human rights. But I think what I was going to say, and that I kind of have struggled with to respond to in some ways, is some folks think that it's because of mass incarceration that we have an abolitionist movement, and that doesn't apply other places. Or that because of the racism in the United States, and that doesn't apply. So I have kind of that apologetic why I'm looking at Europe, in order to say, yeah, actually you all have many of the problems that we have that you're not wanting to acknowledge, even if it's not mass incarceration. But that's more, mass incarceration is the evidence of it really more than the cause of it. I don't know, I'd have to think a lot about that.
Julia?
Thank you so much, Professor Engle, as well. I have maybe a very specific question, but you spoke about in the paper specifically specifically about the kind of responses in the context of international pressure for femicide when you were talking about in Ciudad Juarez and how sometimes states automatically respond to pressure to reduce, specifically in this case, femicide by over-policing. And one question I had was how, because those are never necessarily, or they haven't necessarily been recommendations that have been made by like the Special Rapporteur on Violence Against Women when she was asking for increased femicide watches or responses to that. Those recommendations weren't increased policing or increased police activity or response, but states interpret them that way a lot of times. And I was wondering if you've seen examples, positive examples, in the ways that abolitionists might have worked in this moment to change how the interpretation is always respond to violence with violence as opposed to non-carceral or non-violent ways of response.
Yeah, you might be surprised at how the explicit, not just recommendations, but I can tell you there's a judgment from the Inter-American Court of Human Rights, the Cottonfield case, that explicitly called on Mexico to investigate, prosecute, and punish, right, the murders. And actually, you know, treating them a lot like the enforced disappearances, because that's where they sort of fit in. You know, and the example, and I have a little bit more of it in another piece, is that pressure that was coming on Mexico, and I'm not gonna be able to tell you if it was before or after that decision. So you're right that I'm experiencing it as a larger pressure. You know, and it's a particularly egregious example, just where Mexico arrested some people, tortured them. There was no evidence that they were all involved, and we're like, look, we took care of it. And then there are some examples in the UK Modern Slavery Act that others have shown something similar happening. And so, yeah, but that wasn't really, that's responding to the assumption behind the question, but not really the question. So the question is, let's say that they didn't call on it, or that those arrests happened before that decision. Is there some way that we could try to get, and then would it be human rights advocacy to encourage states to do something different? Is that the question?
Yeah, I guess kind of with that, like in places where there isn't maybe as much international pressure as there has been, like and the OAS has done a lot of other things with their own laws around GDP, but thinking about positive examples where specifically gender-based violence activists have been able to say responses should not include and been successful in terms of.
I mean, I think the biggest successes of that, but there are others who are not better than I, are certain states in the United States, right? Who have, and like the decrease in mandatory arrests, and there's been a pretty significant change there. I don't know if some of that's been in state law or not. And I think it's an important reminder that it's not saying, so what I just suggested in response to Daniel was, it seems like it wouldn't be enough for the European Court of Human Rights, and probably the Inter-American Court, I can see too, if states said, we're not investigating, prosecuting, and punishing, because we have this whole other way to go about the issue. But it doesn't mean that states can't, at least, that was what the 5 or 6 Ps, right? That was that person was saying, yeah, do that, but do these other things too. So I think that there are different ways that can be proposed, and maybe working, through. The treaty bodies have also, like CEDAW has come down pretty squarely, but that's what I'm trying to do, is like get folks, at least some empowered, to say, do we have to do this? Why do we have to? Who said we had to do this?
A lively discussion on Tuesday, so I know you all have strong thoughts on this piece.
Yeah.
Hi, I just have a bit of a broader question. So I know you got a lot at the inter-American system, the European system. And, in Africa, we are moving away, finding that we are moving away from traditional and transitional justice, which is less, focused on the carceral system, moving more towards the criminal system. And you see this within the African Union as well. So there, we had the African Court of Human People's Rights, and there are plans to merge it with the new Court of Justice and Human Rights. And it covers the justice sort of part of the court covers, I think, something like 14 crimes, which are transnational and ICC crimes. But I wonder what your thoughts are on, combining sort of Court of Justice and a Human Rights Court, and what that's going to look like. I mean, I have serious concerns about it, but I don't know if you've looked into that at all. I know in one of your pieces you did look at the African Commission on Human People's Rights and how they have adopted the Inter-American Court's practice on amnesty. But I wonder if you just looked at that a little bit more.
Yeah, do you write papers in this course? That needs to be written. So, because I haven't, I mean, the truth is that I tend to, I've had a research assistant who's supposed to be looking at these African cases and keeps saying that she's not really finding that many of them. And I think part of it is, right, that the court, there are only 6 states that have agreed to the
Protocol, another protocol, I think, yeah.
No, to the jurisdiction of the court.
Oh, yeah, well, it's not even.
So you don't have that many cases anyway. So even if they sign on them up to protocol. The commission obviously has much more, but that will continue as its own distinct, right? So I don't know. I mean, it's an interesting question, and I'd love to hear more about it if you've been following it and have thoughts. Because I kind of every year read and I'm like, what's happening now? In race class, and I don't, and then I see that, there are fewer and fewer states that are, and I think that might be part of why they're doing it. But I don't think that the case law of the court right now has been, I don't know. I mean, cases I know of, I wouldn't say have been that influenced by the carceral turn, but it's an open question in terms of, I don't know how it's going to work in terms of complaints. I just don't know enough.
It's also very difficult to access any of it. I mean, not as accessible the case law in Africa, African Union. You have to dig a hole.
Yeah, I know.
Cleveland, you're already off the hook.
What?
Cleveland, you're already off the hook.
Okay, I understand.
And not general region. Yeah, that's right.
Karen.
Hi.
So I'm with the paper, I'm afraid, and so this may be something that you talk about there, but it strikes me if you're talking about violence against women particularly, that there was such a struggle, decades ago to try to make that a public concern, make that an issue of public concern, and that one of the concerns about some of the reforms that you're talking about would be, that's suggesting that it should be treated differently, that there's a real impetus to have it treated the same as other criminal activity, but because of the history. And so I wonder, I guess, whether that's whether feminists should be the ones that are criticized for pushing this, because what they've been trying to do for decades is to have it be recognized as a public policy concern.
Yeah. Sorry.
That's all.
No, I mean, so part of the idea of the paper, and I didn't give as many examples of it, but is to show that feminist abolitionists have also been quite concerned about it, and in different ways, right? So, I mean, I think feminist but even to go back before that, maybe I should make this clear if it's not in the paper. I mean, I'm using racialized and gendered violence because I think they're the hardest cases, but obviously I would apply all of this to everything. So it's not like, and I think some feminist abolitionists have felt the need to say that. Like, we're not saying people should get off there should be no incarceration or no penal sanctions for this kind of violence against women or that kind, and it should be for everyone else. No, I mean, it's obviously, the idea is that this is an abolitionist vision. But feminist abolitionists, and I talk a lot about this group, this coalition, this document and coalition called Insight, that was feminist abolitionists put together largely to get abolitionists to take seriously, like to say, we can't just pretend that violence against women is not, we think of all violence is serious, but let's just make it really clear that we also think that violence against women is serious, and let's have attention to that in all of our abolitionist aims and goals. And so, and that's when I mentioned Verges in France. She's kind of come back to do that more recently from a decolonial perspective and saying, actually, this isn't new. I mean, feminists were saying this in the 70s also. So some of it is just recovering, different approaches within feminist movements, and then saying, yeah, I mean, you can understand that that was the struggle and that there was success in many ways to get attention to it, not in other ways, right? I mean, that's the flip side. Like, we know criminal law hasn't solved most of what it was meant to solve, but in terms of at least putting it on the agenda as a serious issue, that's been accepted, it seems like, by the court. But then if that's accepted by the court, then it needs to figure out a better way to respond to it. So that's kind of what I'm trying to do.
Oh, yeah.
So I wanted to kind of revise one of my questions that I asked in my paper.
No time like the present.
So I think you referenced it a little bit, but I asked about like sort of what the implications would be in this like world where the court can resolve these issues by having like damages awarded in scaled amounts to like expressively show the gravity of the crime, right? I was kind of like asking what would that mean for like, I don't know, like reinforcing like wealth disparities and stuff like that. And I think the way I formulated it at that time was based on like this sort of idea I had of like individuals paying out these amounts, which after listening to you, I see like is not how this court operates or like wouldn't make sense. But I do, like, I've been sitting here like going over it in my head, and I'm like, I do still think it could, like the question could still stand in some ways, because it seems like in a world where that is how this court operates, there would be like far less consequences for wealthy nations to violate human rights or like fail to investigate, prevent whatever human rights abuses than poorer countries. And even like in the even for wealthier countries, when they are like paying out these amounts, like the sort of downstream implications of that is still going to be like taking away from like welfare programs and things like that. So not that like it's like, okay, what else can we do besides money, because there doesn't seem to, like, I don't know, but there doesn't seem to be like something right now. But I'm just kind of wondering what you make of that, or what other people are thinking about that.
Yeah, look, that's a great question, and it's a question that's in international law more broadly, and I presume I'll just stick with the international law. So if you find a state hold, this was with Serbia and the genocide cases, right? So you hold them accountable, and then maybe Serbia's not the best one. There was the Bosnia case, right? And countries trying to reform. It's rebuilding. When any country's rebuilding, do you want to have them pay regardless of how responsible they were? Do you want to have the funds going to paying particular victims as opposed to the whole? Because there always are particular named victims, right? As opposed to the whole country. And look, there's a problem with this paper. There's a problem with this paper that maybe you all can help me with. And it's interesting, because I said this was the first time I presented. It's the first time since I wrote the whole last section. But the real reason I focused on Europe is because I got asked to write a paper for a conference on the European Court of Human Rights by those courts of human rights people. So I went, I did it, and I got into it. because I find those cases kind of hard to read, to tell you the truth. So, but so many of those cases, so I don't know if anybody noticed it in the paper, they're Eastern European countries. A lot of them are Russia. Russia's no longer a member of the Council of Europe, so, but a lot of them are Eastern European countries, and a lot of them are countries that are a lot less wealthy. So my simple answer to you is, actually, the way that damages work now, they differ depending on what the state can actually provide. So in fact, that's true. And a lot of people critique that. Still, not a lot of stuff I can find in English. But then in French, there's stuff on those damages. But, you know, the critique of that is, well, why should a victim, you know, be worth more, their harm be worth more than the harm of a victim from another state, but also they're living in that state, presumably under that economy. So so it would be less that the state would pay, but it would hurt the same, right? Would be the idea. But the problem that with the paper that I can't quite figure out how to talk about, and I couldn't get any of those Europeans to help me figure it out, is that, you know, so what's going on here? I mean, there are a lot of French cases around race, but most of those cases, at least, okay, the UK, there are quite a few on the police violence. But, you know, is it that exhaustion of remedies, so that complainants are exhausting their remedies and without effect, and therefore getting to the court, whereas in other countries, the West Europe countries, they can't get past, you know, the cases are basically seeing that they were attended to domestically, where they actually attended to domestically. But I kind of think something else is going on about who is seen as the bad states versus the good states. And I don't like have enough to be able to make that argument. And I think that would also, you know, you'd have to be wary of that, I suppose, in thinking about what those damages would look like as well, maybe. And especially, but yeah, if over and over, but already that's happening, over and over, those are the states who are obligated to investigate, prosecute, and punish. And the others are seen to basically, I don't know, not finding the cases. That's all I can say. So I appreciate the question. And I appreciate because I was worried that it was reading as though I was suggesting that private violators somehow paid out, which was not the idea. But yeah, there are always costs to getting, but that's true of human rights generally, right? In a civil court and having damages paid. And the other thing, for the larger comparative, right, is thinking again about maybe some of the European courts' more symbolic efforts that might have some effect beyond the symbolic. The fact that I've said that now twice makes me think that little book can only be 30,000 words, and it's 29,500. So I don't, you know, I gotta cut. So if you have ideas for what I should cut.
That was not part of the
I have
assignment.
to cut it over here. What?
That was not part of the assignment, but you know, we'll do that for next week and cut parts out. Yeah, cool.
So something that I've been thinking about, and a question you actually posed in your presentation, is whether positive reform should be pursued in an effort to allow for more humane treatment of folks in prisons, and if that's subsequently diminishing the ability for abolitionist perspective to be pursued in that. So I was just curious what your opinion on that is.
Yeah. So, you know, there are easier cases and harder cases. So I think if we're talking about the conditions in existing prisons where people are, and you're making it, you know, and thinking about it quite deliberately. So I do think these are also, again, very case by case a lot. I don't know. I find myself compelled by a lot of the incarcerated folks and formerly incarcerated folks who are calling for better prison conditions. If they require like a lot of money that could be going somewhere else, I mean, right? So then should the efforts be to try to get the state, and what if you can't? Like those are all the things, right? To distribute the money differently. There've been a lot of battles has been around building of new prisons. And sometimes the building of new prisons is seen as the way to respond to all of the problems, but, you know, I guess kind of like to ask that question of who benefits from that, and who loses from that, and it's pretty clear who benefits from it, and meanwhile, you know, maybe people are incarcerated in, well, more people, because jails are usually bigger. So that, like, if you're gonna fight overcrowding, that's probably not the best way to fight it. But yeah, I think a lot of alliances have to be, you know, we need alliances, and it seems like people are doing the work for improving and calling attention to conditions, you know, is really important work. But I'd like to see them doing it in coalition with people who are trying to change things more systematically.
Up on what you were saying about like symbolic value and also issues of like people having traditionally thought in terms of punishment and crime as ways of the state eliminating responsibility. If there was a shift away from carceralism, this question is a little bit vague, but like, do you think that people would see it as a symbol, as like less of a commitment to it? Because I know the paper is really is pointing out like all the problems that come from this and how it doesn't really necessarily like stop further crimes. But just on like the symbolic level, do you think enough people care about what's happening right now in these countries, like non-academics, non-lawyers, it would make much of a difference? This is a little jumbled, this question. But like I'm basically asking, do you think reparations have the same level of like symbolic resonance for people in terms of state responsibility, given that it's obviously not as common as putting people in prison? Do you think that people would feel like there's less of a magnifying glass on populations? I'm not saying like, even if there were, I'm not saying it would be bad, but I'm just wondering like, on the symbolic level, if you think that.
Yeah, I mean, it sounds like you have a hunch that it wouldn't. But it's interesting because then when you kept going, I loved it. Like, I mean, reparations, you can find a lot more written about the Chicago reparations than about some individual who was incarcerated, right? So maybe that would be the goal, for that to become more common, and then we wouldn't pay attention to it anymore. But actually we would, because it would cost states, and it would hopefully make conditions much, much better in the communities that are currently marginalized, subordinated, oppressed, etc. So I think that's, you know, I mean, it's kind of, that's the, I've always been a little ambivalent about the expressive function idea, but somebody liked it in their paper, so I went with it. Who liked it? One of you got it. And I think it is, right, to say, but that's part of how I want to hold them to it. Like, okay, you really care about this. But, you know, does it really, I don't want to take it as a given that it actually functions to call accountability, to put the magnifying glass on and all of that, right? I think that people think that, you know, that's the only way you can get certain kinds of harms taken seriously, but if taken seriously means investigating, prosecuting, and punishing, but not changing underlying structures, etc., then maybe, I mean, so there are two parts to it. One is, I guess, the effective one, like, do we care if conditions change? Do we need a spotlight? And the other is actually what does create the spotlight.
Well, I think in Chicago, the folks that were working on this one vote, they wanted prosecution and criminal sanctions for Burge. They weren't able to get anything very satisfactory. And, you know, then they were able to move
interesting point that, and I do acknowledge that they were unable to bring a criminal lawsuit. But that everybody who's written about it, as far as I can tell, who is behind the litigation, and the settlements and and the abolitionists who have lauded it, say this was the most important part. And that they, but that's with hindsight, I mean, who knows, right? But I think it's interesting to actually to think about too, if they'd gotten the criminal response, then would it have taken the wind out of the sails of the reparations? I think probably not in that case, but it's hard to know because it went on for so long.
I know we're coming close to time, but I'm going to ask a question.
You?
I know, I'm very surprised. So, I mean, well, many, but a couple of them. So one is that, I was curious about, Professor Bedford mentioned the vulnerability thing, and I was curious in the paper too about, is vulnerability as used the problem because it is always linked up to carcerality, or is vulnerability something that can be potentially detached, and would that be useful or not? Because it feels like it gets mobilized in a very specific way, both at the court and more generally in human rights, which you and I both have lots of questions about. But on the other hand, there can be utility to it. And I'm a little stuck because, of course, in the lines of sort of feminist critical thought and your other work, right, we have all these questions about sort of what it means to figure certain groups as vulnerable and what that does with agency and lots of other things that would play into the abolitionist arguments. So that's sort of one question. And the other is more, I haven't worked it out yet, so I think it's more of a question to just think about, which is that there's some meeting point here about hierarchies of harms, right, that have to do somehow with a nexus point between who you're protecting. It's a vulnerable group, and so we need to protect them more, and we have an equation in our minds, which means more protection is more carcerality. Then there's a piece that says the gravity of the harm is increased because a particular group is being harmed, and that's something that we see in not only human rights law, but very much in international criminal law, where the idea is there is a hierarchy of harms. Some things are so bad, they have to go to international criminal law. So there's some embedded notion, it seems to me, operating in the backdrop here, where the kind of criminal approach as always the thing that showed, this is back a little bit to the expressive function, but I think not only, is the marker of how we deem certain harms and against certain groups as always being the worst ones, right? If you're harming a group because it's a group, or if you're trying to, right, because it's women, then they're vulnerable, and then it's worse. And if it's worse, we have to do the worst thing, and the worst thing is we punish people through imprisonment. So there's a lot of work being done by those concepts, and like I said, this piece is more a comment than a question. I think the first one's more a question, which is just sort of, can vulnerability be detached from carcerality? Is my more pithy question.
Yeah.
Not that I'm ever pithy.
It's of course, a tough question from you here at the end. But I will say that when Professor Medway said he loved that part, I thought, I was thinking of cutting it.
We won't.
I'm gonna say that now he's gone. And the reason is because so part of it is just, I'm not actually sure doctrinally that the vulnerability works all the way through. I do think that it's something about, I think because hate crimes, right? So I mean, gender-based violence is seen as a hate crime, but not called that, right? And then some kind of the gendered and racialized covers a lot. So then the racialized and the homophobic and transphobic violence, they don't necessarily use the language of vulnerability, but they definitely use, right? And they don't say subordinated. What do they say? The groups who are discriminated against. They use Article 14. But there's an idea that somehow the harm is worse. I think that, so yeah, so that would be an answer to your question. No. Is it no or yes? I'm not sure. So is it have to be tied to carcerality? No, because I think there are other functions. It's in the other cases, yeah, because some of the same things are happening without that designation. And that designation is doing more than just the invocation of harsher sentences, punishment. But it seemed to me that in the domestic violence cases, it is playing, so it's maybe is my answer. But I need to go back and look through it more, because it is, when they finally say every victim of domestic violence is vulnerable, that's kind of like a weird thing. Like, you become vulnerable because you were harmed, because the crime happened to you, whereas before it was like the crime happened to you because you were vulnerable. So there are different ideas there that are definitely worth teasing out. And I'm not sure that, like, I thought that was going to be really present. I did the gender-based violence part first, and then I didn't see it play out exactly the same. So yeah, with the last reading, I actually wrote in the comments, should I skip rid of the vulnerability part? Then it did.
Should we take a vote? I'm just kidding. I said, should we take a vote?
Yeah, what do you think?
Section 4, interaction.
Yeah, so, but it, right, and but actually, I think why that's important, that I need to think about, is, as I try to find somebody who knows more about damages in the European Court of Human Rights, I kind of play in, right? Because I'm trying to call the court to account and say, okay, if you really care, you take all of that energy you put into aggravating factor and make it a higher damages award. That was kind of cool, didn't you think? It was kind of a cool thing I came up with in the middle of the night, one night. But, right, like, if that's what it is, let's show it. But even as I was saying it today, the first time I've actually said it, right? I thought, is that really what I think, that the damages should necessarily be greater for, so I was doing the opposite of what you were worried about, Martha, right? I was like, should the damages really be greater for those? No, I want the court to do an analysis. I want the court to do it. I want, to listen to somebody who's doing an analysis. But of how to have reparations for various harms. I appoint Zena Miller for that.
On that note, a huge thank you. That was fantastic, and I think all of us learned.